हेलो फ्रेंड्स, वेलकम यू अगेन टू आवर यूट्यूब चैनल। आपको पता है हम सैलिएंट फीचर्स ऑफ इंडियन कॉन्स्टिट्यूशन पे डिस्कशन कर रहे हैं। जीएस पेपर 2 में ये पॉलिटी कॉन्स्टिट्यूशन के सेक्शन में ये सवाल पूछे जाते हैं इस टॉपिक से। सो लेट्स गेट स्टार्टेड। कुछ फीचर्स हमने उसमें से किया भी है पार्ट 1 पार्ट 2 में। यू नो देयर आर मल्टीपल सैलिएंट फीचर्स ऑफ इंडियन कॉन्स्टिट्यूशन, ऑलमोस्ट 15-16, right? So that's why it is not possible to make you understand all the features which are available in our constitution in one go, in one video. That's why we have divided this whole topic in parts. So this is third part of our discussion, like third video series we are coming with. You see here some of the salient features we have discussed earlier. The first feature was lengthiest written constitution. Our constitution is lengthiest written constitution. We have discussed in detail, and I have made you understand that how it is lengthiest written constitution, and what were the factors which are responsible for our constitution to be lengthiest and written constitution. Those all things we have discussed earlier. The next one was the drawn from various sources. Already we have understood. And the next one was blend of rigidity and flexibility. In detail we have gone through, and if you are not you have missed the videos, earlier videos, then you can go to our previous videos. You can explore, and you will be definitely finding out the video, the concerning video. The next feature was the federal system with unitary bias. This also we have done. And next one was the parliamentary form of government. Yes, up to this point the parliamentary form of government we have done already. So let's do the next three features which are there in our constitution, the salient features. Namely, the sixth one is, which today we are going to do, is the synthesis of parliamentary sovereignty and judicial supremacy. You see here, I have written here for you, synthesis of parliamentary sovereignty and judicial supremacy, right? So this salient feature we are going to discuss today. The seventh one is integrated and independent judiciary. You see here, I have written here for you, integrated and independent judiciary. The next one, the eighth one is, which we are going to do today itself, is the fundamental rights, right? So, these five features we have already done, and these three next features we are going to do today. You be clear about this. Synthesis of parliamentary sovereignty and judicial supremacy, integrated and independent judiciary, and fundamental rights, right? So let's get started and try to do these three features today. Be focused, try to understand what we are discussing here. And if you have any query regarding, I'm not audible, or it may be like the language is something which you may not understand, or some any kind of issue, or you may not find clarity in my discussion, you raise your questions through comments, right? And we'll be redressing those grievances raised by you guys. And if the problem persists, or the problem is some kind of like major problem, then our team will reach out to you, and for sure we'll address the grievance raised by you. Our motto is to teach you, to make you understand properly, with clarity, with precision, with practice, right? That's our motto. We are fully dedicated to your service, right? And in return, you can subscribe our channel, like our channel, and promote, like you can share our channel with your friends, with your colleagues. So let's get started by without wasting our time. The next feature is the synthesis of parliamentary sovereignty and judicial supremacy. You see here, our constitution is like, our constitution is not like judicial supremacy. Our constitution has not established judicial supremacy or outmost judicial supremacy. Neither this, nor parliamentary sovereignty, right? Let's try to understand what judicial supremacy means, what parliamentary sovereignty means, right? So judicial supremacy simply means that judiciary of the land, right, must be supreme. The verdict of the Supreme Court cannot be questioned anywhere, right? Parliament cannot overrule the judicial verdicts. If the scenario is like this, then that particular constitution or that particular case is called as the judicial supremacy. There are several countries, prominently the USA in the world, which follow the principle of judicial supremacy. So you can imagine how powerful the Supreme Court of or the Federal Court of USA is, right? Very powerful, because no institution, no body of the country, no institution, no individual can challenge the verdict of the Supreme Court or the Federal Court of the USA. This is called the judicial supremacy. Judiciary is supreme. Nobody can question, right? So this is one. The second one is the parliamentary sovereignty. This concept is like, if in your country the parliament makes whatever law it on its choice, in our country also whatever our parliamentarian wish to make law, they make law, they proceed with the bill, and after the passage procedure followed in the parliament, the bill becomes law, right? But once the law is made, is that unquestionable? This is the big question, right? Is that unquestionable? No authority can challenge the law enacted by the parliament, or the law made by the parliament can be challenged in any court of law or with any authority or public in general, right? If you start discussing this question, then you come to know what is the parliamentary sovereignty. If the law enacted by the parliament cannot be questioned in any court of law or in any authority or in any body, then that concept is called the parliamentary sovereignty, right? Parliament is sovereign. Sovereign means outmost level of autonomy, independence. So if parliament has parliament is enjoying outmost level of autonomy and independence, then of course the laws made by parliament cannot be questioned in any court of law or in any authority, right? Authority holding body or something like that. So this concept is called the parliamentary sovereignty. Parliament is sovereign, parliament is autonomous, parliament can do whatever, right? Literally whatever. So and if we try to examine our case where we are, right, we follow judicial supremacy or parliamentary sovereignty, then your question, your obvious common sense, you apply your common sense, and your answer will be like, no, we neither follow judicial supremacy nor follow parliamentary sovereignty, right? What we are a synthesis of both. We have taken few elements from the judicial supremacy and few elements from the parliamentary sovereignty. We have not literally followed any one concept, right? So as I have told you, the judicial supremacy concept is popular or adopted by the USA, and the parliamentary sovereignty is in UK or Britain, right? And one more thing I want to tell you here, the judicial supremacy concept is based on the due process of law. Due process of law and the procedure established by law, right? You see here, there are two concepts, due process of law and procedure established by law. So accordingly, as we are saying the parliamentary sovereignty, so parliament is sovereign as long as the laid down procedures are followed, right? Like the laid down procedures are followed, parliament is free to enact any law, and that law shall not lose its validity. That shall be valid, that shall be a kind of sacrosanct, that shall be continuing, that shall become the law of the land, right? So this concept is called the procedure established by law. As long as the procedure laid down to make the law is followed, the law shall be continuing, law shall not lose its validity, right? See, the procedure established by law and the due process of law is kind of very important topic to discuss. We'll be dealing with these two topics in detail in our fundamental rights, when we'll be doing fundamental rights with focus and in detail. Then we'll be dealing with these topics. For time being, you just understand if the procedure is followed to make the laws, then parliamentary laws can never lose their sanctity, their validity. What is the due process of law? Irrespective of the procedure, whether it is followed or not by the parliament to enact the law or the legislature in general to enact a law, the Supreme Court or the judiciary will get into the the natural justice concept of the law, right? The natural justice, if law feels violative of the fundamental rights, if law is like it is hampering with the liberties of the people, then Supreme Court shall declare that particular law null and void, irrespective of the procedure followed, right? So here procedure is important. Here the concept of natural justice is important. If the law is not justiciable, it is not doing justice to the people of the land, right? Then that law shall be declared null and void by the Supreme Court. That's why you see here there is judicial supremacy. Supreme Court decides which law is going to continue in the country, in the land. Here Parliament decides which law is going to continue in that particular country. So let's move ahead and try to understand next things. The next feature I've written here for you is the integrated and independent judiciary. Right? Integrated and independent judiciary. You see here, our system, our country, our forefathers has opted for the integrated and independent judiciary to ensure, to establish justice in the society, right? So at the top of our judiciary system, there is Supreme Court of India. I've written here for you, SC, right? Supreme Court of India. And below to it there are high courts, or for the states, or two or one common high court for two states or more states, and then district courts and other courts. This is proper courts, judiciary hierarchy of our country. It is integrated. There is no demarcation, there is no separation. And on the other hand, if we see the USA's judiciary system, USA, they have their federal court at the top and the states court, at the intermediate level, then lower court also they have, right? So you see the difference between them. Federal court is there to enforce, to ensure the justice, to do the arbitration, or to entertain the cases which have federal ramifications, right? And the state courts are there to enforce state laws, right? The laws concerning with the state matters. The dedicated courts are there for the states, other local courts are there. Here you see there is one integrated court, Supreme Court and then high courts. Here there is no demarcation, right? So this is the basic difference. We have not created the dedicated state courts. It is not like that, right? So this is our court system, our judicial system. Now our Supreme Court is highest court of appeal, right? Whatever matters come in, even in the lower court, then high courts, the highest court of appeal is the Supreme Court of India, right? The next point is the guarantor of fundamental rights. Our Supreme Court is guarantor of fundamental rights and the guardian of the Indian Constitution, right? So if our Supreme Court has a great eminence, great importance in our constitution, in our political system, that's why its independence is very important, very crucial. If that body which is arbitrating between the disputes which arise between the states and the union government, or amongst the states, or individual and the state, so if that particular body is not going to independent and autonomous, then justice system is going to be pay the price. Justice system is going to be hampered or compromised. That's why we have ensured in the constitution itself the independence and autonomy of our judicial system, or our judiciary in general. You see here what are the measures we have taken through our constitution to ensure the independence of our judiciary. Security of tenure. We have ensured the security of tenure to our judges, to our judicial officials, right? The next one is fixed service condition. Their service conditions are properly laid down or written down in the constitution, in the document itself. Those cannot be changed arbitrarily, right? So they have got fixed service condition. They have security of tenure. Their expenses, like their salaries and their allowances and their pensions, etc., are charged on the consolidated fund of India. Those expenses are charged expenses, charge expenses category. When we'll be dealing with the financial issues of Indian constitution, right, then we'll be or the budget in general, then we'll be discussing this. what are the charged expenditure. Basically, for time being, you understand this much: the charge expenditure, the expenses which are charged on the consolidated fund of India, those expenses are not does not depend on the choice or likes and dislikes of the legislature, right? They are a kind of, the legislature interference gets minimized. That is the point, right? Okay. Next one is punishment for the contempt of court. Somebody or some institution or some like organization who is humiliating the judicial system or the questioning the judicial system. Yes, I would say the question is not bad. It comes under the right to freedom of speech and expression. But whosoever hurts the Supreme Court or questions the administrative part of the Supreme Court or questions the conduct of the Supreme Court, judges, Supreme Court and High Courts can issue the what you see here, the contempt of court to that individual or that body. The next one, conduct of the judges cannot be discussed in the legislature or the state assemblies. The Supreme Court and High Court judges conduct, how they perform, how they deliver justice or something like that, cannot be discussed in any legislature, right? This is also a kind of protection they have got. Separation of judiciary from executive. We have made provision in our constitution to ensure that judiciary and executive needs to be separate. So this much we have done. Let's come to the next point. Next feature of our Indian constitution, that is the fundamental rights. You see here, I have written here for you fundamental rights. There are 6 set of rights under part 3rd of the constitution, which are called the fundamental rights. Why they are called the fundamental rights? They are very fundamental, they are very basic for the existence of individual or the community, right? They are very basic. People feel like, we have got fundamental rights, they are very kind of great rights. So I would say they are very basic. If you are going to satisfied with the bare minimum, then it's okay. They are very basic, they are very kind of elementary kind of rights. We should be happy when we get something more than the fundamental rights. Yes, fundamental rights are of course great, they are very necessary, very kind of very important for the free and independent existence of individual and the communities. But we need much more than this, right? Beyond fundamental rights, we question the government that provide us some new things, add some new fundamental rights, right? And the journey is continuing. With the passage of time, very often Supreme Courts come up with the new concepts and adds so many fundamental rights. Earlier, so many fundamental rights has been added, and we are quite hopeful that this list goes continuously, and then only will be like, this list is good one. And this, I would say, this list is not exhaustive. We must continue with this journey, right? So because these rights are very elementary, very primary, very kind of fundamental in nature for the free and independent and autonomous existence of the individual and communities, that's why these rights are called the fundamental rights. I have told you, under the part 3rd of our constitution, the 6 set of fundamental rights we have got. Namely, you see here, article 14 to 18, right to equality. Right to equality, you understand? Samanata ka adhikar, right? The next one is article 19 to 22, right to freedom. Various kind of freedoms we enjoy, right? And those freedoms are written from article 19 to 22. Then comes article 23 to 24, this right to, you see here, right against exploitation, right? तो शोषण के विरुद्ध अधिकार हमको आर्टिकल 23 से 24 के अंदर मिले हैं, 23 to 24 मिले हुए हैं. Then we come to आर्टिकल 25 to 28, राइट टू फ्रीडम ऑफ रिलीजन. हमको अपना धर्म मानने के लिए, उसको प्रोपेगेट करने के लिए, एडवर्टाइज करने के लिए, पब्लिसिटी करने के लिए, अपनी कॉन्शियंस की आवाज को सुनने के लिए ढेर सारे तरह के राइट्स मिले हुए हैं. प्रिसाइजली हम one by one each and every aspect of each fundamental rights will be discussing when we'll be discussing the fundamental rights separately, right? But here we are doing this much only. तो धार्मिक स्वतंत्रता का भी अधिकार हमको मिला है. this article 25 to 28. Then comes article 29 to 30, cultural and educational rights. You see here, cultural and educational right. We have right to preserve, to protect our culture, right, and establish our educational institution which are based on the cultural things, right, cultural roots. So this right, fantastic, beautiful right we have got. The last one is the article 32, right to constitutional remedy. This is the most important rights, because if this right is not there, then these rights does not make any sense, right, because this right ensures the enforcement of these rights. So this much, this is the exhaustive list of the fundamental rights, but as I've told you, the journey shall continue. We hope to add more new fundamental rights in our list, right? So let's move ahead and try to understand. Fundamental rights works as a check on executive on the tyranny of the government and arbitrary laws made by the legislature. What fundamental rights do basically, because fundamental rights are directly protected by the Supreme Court, by the virtue of Article 32, right to constitutional remedy, and aggrieved person can move to high courts also by the virtue of Article 226 to high court, and Supreme Court and high courts accordingly are vested with the writ jurisdiction. There are several 5 types of writs which Supreme Court and high courts enjoy. They issue the writs on the need basis, right, wherever the needs aggrieved party moves the Supreme Court by virtue of Article 32 and high court by virtue of Article 226. Accordingly, Supreme Court and high courts ensure the enforcement of that particular fundamental rights by issuing the writ to the aggrieved party or to the the party in dispute. So that's why we say the fundamental rights ensure the a kind of control, a kind of check on the tyranny of the executive, right? So whatever executive wants to do, executive is free to do, right? And along with the executive, the legislature also, provided executive should not play with the fundamental rights. As long as executive and legislature does not hampering the fundamental rights, or they are not violating the people's fundamental right, they are free to operate, they are free to enact the laws, right? So the fundamental rights work as a kind of check or control on the tyranny of the executive or the government in general, and on the arbitrary laws made by the legislature, right? You understand this much, right? Okay, let's move ahead and try to understand some features of our fundamental rights. Our fundamental rights are justiciable in nature, right? Justiciability is there. If justiciability would not have been there, then fundamental right would not have made any sense, right? Justiciable means simply you understand enforceable, right? इनको लागू किया जाएगा, इनको पारित किया जाएगा और इनका इन्फोर्समेंट इंश्योर किया जाएगा, ऐसा सुप्रीम कोर्ट एंड हाई कोर्ट की रिस्पॉन्सिबिलिटी है. दे आर जस्टिसिएबल. इट इज नॉट लाइक कि हमने लिख दिया है उसको दीज आर फंडामेंटल राइट्स और उनका वायलेशन होगा तो कुछ अच्छा हो नहीं सकता है. It is not like. Directly Supreme Court is vested with the authority to ensure the enforcement of our fundamental rights, right? तो ये जस्टिसिएबल हैं, ये तो बड़ी अच्छी बात है, बहुत खूबसूरत बात है, और यही बात है जो हमारे फंडामेंटल राइट्स को लिविंग और एक अच्छा सेट ऑफ फंडामेंटल राइट्स बनाती है. ठीक है. द नेक्स्ट वन इज फंडामेंटल राइट्स आर नॉट एब्सोल्यूट. Yes, this is some kind of disgusting thing which we have added. Misfortunately, our fundamental rights are not absolute, but there are reasonable restrictions, right? But in the name of reasonable restrictions, we have restricted so many aspects of fundamental rights, which is very misfortunate. I think a rational look needs to be a rational attention needs to be put again on the reasonable restrictions part of our fundamental rights. So various kind of reasonable restrictions are there on our fundamental rights, but their reasonability needs to be looked into again. This is my personal opinion, right? Next one is fundamental rights are not sacrosanct. They are not sacrosanct. It is not like once the fundamental rights have been written in the document, then they cannot be abrogated or new fundamental rights cannot be added. It is not like that, right? As I've told you earlier in the beginning itself, the fundamental rights, the list is not exhaustive. Continuously new fundamental rights are being added. But the elimination is also happening. Once it was done, this elimination was done, the article 19 1 clause 1 and subclause f and article 31, these articles were concerning right to property. Through by using 44th constitutional amendment act 1978, we have abrogated article 19 clause 1 subclause f and article 31, and we have abrogated the right to property from the list of the fundamental rights, and we have made the right to property an ordinary legal right under article 300A part 12, right? You see here. So in the history, I've told you here itself, through 44th constitutional amendment act 1974 1978, sorry, our right to property has been abrogated already. So you can understand this fundamental rights are not sacrosanct. They can be abrogated. They can be, amended by the enactment passed by the parliament, right? And they can be suspended during the emergency. This is also very misfortunate, clause in our constitution. Our fundamental rights can be suspended during the emergency, except two fundamental rights which I've written here for you, article 20 and 21. This right to life and personal liberty, this article concerned with the matter, right? These two articles shall be continuing even during the operation of emergency, imposition of emergency also. But other than these articles, these fundamental rights, others can be suspended during the imposition of emergency. So we are a kind of, emerging democracy, I would say. And on time to time, we need to pay attention to rationalize these things. Or my personal opinion is our fundamental right must continue. They must be, in force even during the emergency also, right? So let's move ahead. We have done these things about the fundamental rights. So for today class, this was our complete discussion. So basically three salient features we have discussed today. You see here in the beginning itself, I've told you the sixth one was synthesis of parliamentary sovereignty and judicial supremacy. The next one was integrated and independent judiciary. The next one was eighth one was the fundamental rights. So in this way, let's wind up our discussion. And in tomorrow's class, we'll be doing three or four new salient features of our Indian Constitution. And again, I appeal to you that whatever query, whatever questions you have in your mind, you raise those questions through comments, or you can connect us with in live also. And I'm quite sure that once you raise your questions, we'll be reach out to you through video or through comment itself. We'll try to satiate you. We'll try to redress your grievances. Your questions shall be answered for sure. We are here totally for your service. So I wish you all the best. Thank you so much for watching. Thank you.